Over to you, Paul.
Okay.
Thanks very much.
Well, welcome everybody. Officially welcome again. We were here a little bit earlier. We're looking at the 5th session today of Fedsas Online. It's a little bit of an emergency. We had expected some sort of changes with regards to the basic education law amendments, but I must admit we did expect a bit more time to actually go through the process and to help advise schools as to where to go in this setup. As Shane mentioned, a lot of what is being discussed I have got on handouts on PDFs that are going to come through to you later, so you can have a look at the detail. In the very beginning, let me tell you there are 3 versions of the comments that are coming through. There's an initial version of 32 pages, which is very lengthy and heavy bedtime reading. There's a shortened summary of 10 pages, and then there's also a shorter version that I put out of 1 page, which has got the links to the other 2 documents as well. So you're welcome to see whichever one works for you, but hopefully we're going to give you a bit of a background as to what we've got when we go through in the process here. I just want to make sure I'm moving on. Yeah, there we go. Okay, what we're going to look at today, folks, is have a look at obviously a bit of an introduction. For those of you that may not be Fedsas members, and I know a lot of you are, but some of you aren't, please just bear with me. A little bit of an introduction as to what Fedsas is. Bear in mind that we're going to be using this recording to promote the public comments throughout the country for the next week. So we do need a little bit of introduction from Fedsas there. We're going to look at the basic education amendment bill and what it entails, some of the overall concerns with regards to BELA as it's known, and then implications of BELA. Will be an opportunity for questions as well. I'm covering some of the main details, and you'll have a look how we go through it. I'm not going to try and cover all 46 proposed amendments, but we're going to have a look and see which ones we can cover, which ones are of most concern, to try and advise schools and the public out there to put comment through as soon as possible and with as much meaning as possible. So just a brief introduction. Fedsas was established in 1994, same time as the white paper on education was released. We've been around for more than 20 years, experience in educational matters, and we're involved in changes and developments that happen in the educational field. We offer assistance and advice across the full spectrum of school governance and management, all the way from RT, which is probably a more recent thing, social media advice. Obviously, we're quite involved with the lawmaking as well, and we act as a mouthpiece for governing bodies with regards to state bodies and the community. The membership, through our membership, we contribute to draft legislation. We have had a number of meetings with regards to this particular change and amendment, and obviously now it's out for public comment, and we're advising members and non-members public how they should be going about looking at these amendments that are taking place. Just a bit of a background. Paul Colditz and Yaka Deacon are the 2 leaders of our organization, and we consider ourselves to be one of the leading educational guidance organizations in the country. We've got more than, I think we've got 2,100 members nationwide, representation in all 9 provinces, 32 full-time managers. We've got 5 full-time experts. As I mentioned, legal, digital, operational, and governance experts across the ambit that we look at in schools. We've got 110 volunteers that serve on our provincial structures as well, that advise us and guide us in our processes from there. Please, before anybody panics, we're sitting with 2,100 members, not 21,000. It's a little typo that does creep into the system when we're operating like we do. So let's have a look at see what we're talking about with the basic education amendment bill. These changes aren't uncommon. Every now and again, there are changes that happen. There was one in 2011. There's obviously been some before, but the changes that are taking place for us are quite drastic. We're quite concerned about them. So basically what we're looking at the 46 proposed amendments that are in the educational law amendment that's come through. It started the process in 2015, hence you might well see it called BELA 2015, and now it's at the point where public comment needs to be put in place, and hence why we're sitting here. The 2 main portions of law that are going to be looked at are the South African Schools Act, Educators Employment of Educators Act, and there are some laws that are going to be are having an effect on the process as well. The labor laws and a few other laws in the country are being affected, but these are where the primary amendments are being looked at. Now, excuse me. Now, obviously, some of these amendments are technical in nature, and some of them we're quite happy with because they clarify the discrepancies, and we support those changes. Some of the changes, some of them are not technical, but we support, and we've been recommending them for another number of years. So we're quite happy that they're taking place as well. some have a lesser concerns and can be debated on merits. We're not going to do that here. That's not the intention today. I really want to focus on the ones that are giving us the main concerns so we can guide schools and the public to comment on them. So we're really looking at the ones that have far-reaching and drastic effects. And those are the ones that I will be discussing today and go through. Ek moet maar eerlik sê, ek het hierdie hele ding in Engels gedoen. As die Afrikaans vra is, julle mag maar wel in Afrikaans vra. Dit is nog maandag, so my Afrikaans, ek het nog baie Afrikaans oor in my stem, so dis nie 'n probleem nie. As daar enige vrae in Afrikaans is, julle is welkom om te vra in Afrikaans as ons later by daardie plek uitkom. So if we have a look at our overall concerns with regards to BELA, the overall impact, if accepted and implemented, and I think we've got to understand that it hasn't been accepted or implemented yet. It's just in the proposal stage. And obviously we're concerned about what would happen if it was accepted and implemented. Big question everybody's going to ask is this going to happen or not? I don't really know. We're very fortunate that at our Fedsas staff conference, we're going to have a gentleman by the name of Mr. James Ndlebe involved. And he's fairly well placed within governance and management of the education department nationally. So when he speaks to us in about 2 weeks' time, we'll have a better idea of where we're actually going with this whole process and how much we're going to be listening to public comment. But public comment is important. Even if we don't use it now, we might have to use it down at appeal stage. So that's hence why it's very important. But we are concerned that the overall impact of these changes are going to diminish parents' rights through curtailment of governing bodies' power. If these proposals go through, it will fundamentally affect the important norm of our democratic dispensation. It will take the public out of public schools, will infringe on the defined autonomy of parents and members of the school community. Sorry, sorry about that. To decide on domestic affairs of their schools, will basically take away the role of parents and move to a centralized control in the provincial departments. And it will clearly be a totalitarian intervention process, which we're very concerned about. It removes democracy from the system. Essentially, in very broad terms, it will deny the rights of parents with their role to provide, support, participate, and develop public educational institutes. So in an overall view, very colorful, that's really what our concerns are about. But we need to look at the individual items, and we need to see how we're going to handle those from there. And baie dankie vir die mooi woorde, Rian. If we carry on and have a look at the implications, and basically what I've done, I've looked at the main concerns that we've got, and I've put the implications down there. So it's fairly lengthy to go through the process, but I've basically said, let's have a look at the main concerns that we have and what the implications are. I'll already let you know that we can't copy and paste. Well, it's not advisable for us to copy and paste all the comments and send them through to the necessary people, because it's then going to look like it's been a coerced effort and everybody's commenting the same thing, and it's not going to create a real picture. So we're really asking schools and public to take our comments and reword them, look at them and see how they're affecting your schools. Already in a few discussions, I've had some things that have popped up that I haven't even got on here, but they impact on their school individually. And that's really what this public comment is about, is to have a look and see how these implications are going to affect your school. Okay, the first one we're looking at is admission policy and language policy, and how we're going to handle that process. There's clauses in the amendments that have gone through, and clause 3 provides that the HRD has the final authority to admit a learner into a public school. Clause 4, combined with that, provides that the HRD has a final authority on the language policy of the school. Now, there are provisos, and there's a description that the governing body must submit admissions an amendment for the HRD's approval. The HRD needs to take into account the certain factors when considering the policy and the amendment thereof. So that is already in place. But our real concern is that the power rests with the HRD to approve and disapprove language and admission policies. Those of you that handle admissions, and most of the principals will understand what I'm saying here, you handle admissions on an annual basis. You know what a crush we've got on the better performing schools, for want of a better word, or the schools that are sought after. This will then take that whole admission process. If we look at the admissions first, it will take that whole admission process out of the hand of the governing body, and it will put it into the authority of the department. Both policies, we are concerned, the implications that we look at are concerns about the magnitude of the task. Okay, the incapacity of the education departments, the various provincial education departments, to actually perform assessments on individual admission and language policies per school. So we're going to end up with a copy and paste type scenario, and we're going to get sent policies that say you will adhere to them without considering how the individual schools operate. Just roughly 24,000 schools, which means 48,000 policies in South Africa, 12,000 policies in KZN alone. There's absolutely no way that there's a capacity for anybody to look at those on an individual basis with assessment and due consideration to an individual school. So the magnitude of the task is really a huge concern. And then the problem comes is if it's not done, and if there's no response to any concerns, then you don't have a valid policy. So how do you handle your admission processes? Or how do you go forward on your language policies when you don't have an approval from the HID coming through? If we look directly and with regards to the admission policy, there's no input from the governing bodies on the capacity of the school. So some schools are older schools and they've got smaller classrooms, and they're going to be told you will just take that many number of learners, because it is going to become a paper effort. It's not going to become, as I said, an individual assessment. There's no obligation to consult. So while they will say the governing bodies need approval, I really don't feel in any of the provinces there's going to be true consultation. We've experienced consultation processes with the education department, and they aren't often real consultation processes. We find there's going to be a real concern, especially where parents have funded for the operational costs, okay, like extra teachers, extra classrooms that schools have added on, extra facilities that they've added on. Parents have paid for that. They want an input where the process is going, and they're going to be very unhappy. And parents will not continue to fund the huge shortfall with removal of input into operational guides. So if they're suddenly told, parents are told, well, this is what's going to happen, our fear is that parents are going to say, well, should we still be involved in this school because you don't have the public input? So that's on the admission policy side. On the language policy side, single medium education is the most cost effective in a cash constrained system. Okay, having one language that you're teaching allows you at the very best to fulfill your obligation to provide quality education in the best manner. As soon as you move to multiple and dual medium languages, you're going to have a problem. And the concern is that the HID can determine your language policy. He can say your language policy needs to change because population groups in the areas have changed. There's no consideration for funding on a more expensive model. So in what the consideration is of the language policy change, there's nothing saying, yes, funding will be provided towards it, okay? And we know that the present funding model is not working, okay? We know there's a shortfall of money, particularly for the KwaZulu-Natal folks. You know that money's not coming through from the department as it should. I need to make that distinction because we may have people from outside of the province, but in other provinces, there's also cash-strapped models happening as well. And language policy, by the implications that they're putting in there, are going to make it a very, very expensive education process, and we can't afford it. We can't manage the present process at the moment. Already we're in a situation that in KZN, as you see there, not paying schools as they should be getting paid from that side, and there's already a concern there. So our main concern is there's no consideration for the extra costs in providing quality education in multiple languages. So that's really something we've got to consider. Mother tongue education is a constitutional right, and we need to make sure it maintains in the place that it does from there. As soon as we go to dual medium, we start losing part of mother tongue on one side, and we start having a very expensive model as well. So that's the consideration. You put your proposals to remember that we need to have a look at it. It's the funding of this model that's a concern. I think we've already seen a bit of an impact with regards to the introduction of additional African languages, and we've seen that the department hasn't really played ball with bringing resources into a school in most cases, but they have insisted that that extra language comes in. Bringing an extra language into a school is extremely expensive, and our concern is on the financial obligation, whether that's going to be lived up to or not. The present picture, unfortunately, doesn't inspire confidence in improving funding in the future. It's just money is not being spent in the right place, and that's a concern. So already we've got a cash-strapped model. Now we're looking at putting in another language or other languages, and that's going to create a problem as well. Okay, so basically we're concerned that this is really a reluctance to respect, to protect, and promote the values of the Constitution. And that's really what we've got to argue in this process. This is really impacting on the core of the schools to have self-determination, if we want to call it that, with regards to language and admission policy. And obviously, we understand that's got to change, but it's got to change with the right stakeholders on board and not with the decision that's made in the head office miles away from where things are actually happening. So as a result, that's when we put a big red reject button on. So it's not something that we want to entertain and say there's a way about. We need to reject it when we put our comments in place. Okay, the other big one that's causing a problem is the amendments. Then there are a number of them. You'll see 10A, 32, 33, and 35. These are amendments that are going to limit the governing body's power to recommending candidates for appointment. We're talking about if these amendments are accepted, the governing body will not be involved in any management posts. They will only be involved in recommending post-level 1 educators into the system. Obviously, the implications, I don't think we need to paint it too much, but it means that the Department of Education has got the sole mandate to who your management structures in your public schools are. There's no input whatsoever from the governing body. It's very unclear. It is very clear, rather, that these proposed amendments will not solve the problem of undue influence, because that's what the concern is. We've got the memo as well that's come through as to the background of these changes. I've got a copy of that. And one of them was a concern with regards to cash sold jobs and jobs for buddies and things like that, where governing bodies were involved. But this is not going to take that problem away. Unfortunately, the problem doesn't only rest with the governing bodies, it often rests with the officials as well that are involved in this process. And I don't mind saying that on record. I don't mind it being repeated elsewhere. We have got direct proof that that has taken place already in the province. So for us, it's a concern that we're only shifting the problem, we're not actually solving it. The present law allows the department to take over the process should the governing body not fulfill their mandate. And secondly, and most importantly, the governing body needs to be trained by the department. That's one of the department's obligation, that the governing bodies are trained in this appointment process. So now, because some people are not doing their job as governing bodies, the rest of us have got to suffer with these draconian changes, and we have no input with regards to management in the school. So it's very important that we look at it from that aspect, and we say we need to actually call on this one as well and say there is a problem. Obviously, if the amendment is accepted, the next management appointment, and I don't want people to panic, but I think we've got to be very real about it. And that's what the law says. The next management at a public school could well be appointed without any input of the governing body. Once again, the magnitude of that task is sort of unfathomable. We can't really realize how big it is. If we try and put it in figures, the recent KZN Circular 39 of 2017 with regards to the appointment post has 1,861 posts in KZN. Okay, I know from first-hand experience that it takes a day to shortlist, and it can take up to a day to interview when you're going through the process. So now we're looking at lots and lots of man-hours that we need if this is going to be done in a correct HR assessment process for each post. Okay, unfortunately, that's not going to happen, and it's going to be a paper appointment at best. There will not be matching of criteria within regards to different schools. Appointments will just be made with no regard from the HR requirements of that individual school. At best, that's what we'll get. At worst, it'll be job for pals. And that, once again, I'm not putting that on record and saying that's where the problem's going to be. The problem already exists in the province, so it's not going to go away when there's enabling legislation that actually helps the process go forward. It's disastrous for good management, and it's disastrous for providing quality education. That's the big concern that we've got to go through. That also gets a big red reject from us as well, that we can't carry on with this process, and we have to object strongly to this process from here. Okay, the use of school facilities. Clause 10B allows reasonable use under fair conditions determined by the HRD, and that is in italics for a purpose. Reasonable use under fair conditions determined by the HRD for facilities being used without charging for a fee or tariff. Besides some schools relying on this funding, okay, into their inputs into helping them assist schools, so they're hiring out school facilities for weddings or dances or various other functions, okay. It's essentially abuse of power by provincial departments to make use of school facilities without proper compensation, okay. Fee-paying parents have been funding these facilities. They've been handling the maintenance, and this is also one of those that we need to reject and say it's just not fair, if we put it that way, that this facility is going to be used at no financial compensation, okay. The use of these facilities have got financial implications to school. There's maintenance costs, water, electricity bills, cleaning costs, maintenance service. Some of them have been recently built. Funding has been sought from that side. And just to hand these out to someone who's going to decide just reasonable use for education facilities is a concern, okay. Governing bodies have approved these, and expenses will certainly fall outside of their budgets because they won't have advance notice by a year that these are going to be used, so they can't actually plan for them. The big question is who will be liable for these expenses and maintenance, and once again the school and the parents that are paying the school fees are going to be liable for this, and it's not to their benefit. So that's what your school halls would look like, and I think a lot of your schools do look like that, and that's what they could end up looking like. Okay, they could really get wrecked and ruined if we actually don't manage this and we don't fight this process from that side. And that's really what our concern is. We need to consider exactly what we're going to be doing about this clause and how we're going to actually approach it. Okay, central procurement of learning, teaching, support material is a huge concern. Clause 11 seeks to empower the HRD to centrally procure identified learning material. There is a clause there after consultation with the governing body. Once again, how far is that consultation going to go? Present schools have got functions to handle this, and they've been allowed to handle the functions. I've already seen in Natal in certain districts that this is being overridden, and it's either corrupt or it's incapacity. Either corrupt behavior that's not got to be done, or it's incapacity. The district concerned has just basically said you will not receive learner support material from anybody other than someone that's recommended by the department. And I've already been speaking to the likes of Adams and other book suppliers with regards to the process, because they've been caught into this process. And that's essentially what this is going to do. That this information is now going to be in a system that is going to be centrally procured for all schools. And how is the consultation going to take place? Once again, 6,000 odd schools in KZN, they're not getting it right with the present processes. There's incapability to deliver. I'll be polite and call it incapability. Sometimes it's just plain corruption in the delivery process, but it's a huge problem. The proposed amendment will make it compulsory to secure centrally. And that's a concern because governing bodies, we feel, need to have a choice of whether to procure or not centrally. So whether they get goods centrally from one point or whether they go out and they need to have an option, and they need to have alternatives in there. So it's not quite a big rejection, but we need to look at a better system in place on the procurement of LTSM. I think principals, once again, will all nod their head when I say that, is that they want to risk not getting material by ordering it centrally because it doesn't arrive on time. Provinces around the country, Limpopo being one of them, have been through the process that court orders have had to be gained before they start getting material. So we're really concerned that we need to look at alternatives on that process there. Another concern we've got is only an elected member of the governing body component as financial chairperson. So clause 16 provides that only a parent member who's duly elected, not employed at the school, may serve as the chairperson of the finance committee. Our main concern with that is the financial management is quite a complex and involved process in a public school. It's not just a straightforward process. I've sat down with a number of accountants and taught them through the process of how public schools funding works. And a lot of them in the beginning say, whoa, this is really complex because of the parameters that are already in place. So our concern is that with only that person being elected and being allowed to be on that process, the chairperson of the finance committee should at least have some financial background. It's taking away the powers of the governing bodies to co-opt suitably qualified persons for this important function. And often governing bodies do. They'll co-opt someone who's got financial background and say, please, can you serve on our financial committee and guide us in the process? The proposed amendment, if it does go through, will not allow governing bodies to do that. So they won't be allowed to source the extra skill that they are requiring to run their school. It limits the involvement of the South African Institute of Chartered Accountants and other professional organizations who have shown a willingness to help and who have shown a willingness to second their members onto governing bodies to help the financial situation in schools. So it's really a concern that this is limiting it to that sort of scenario, and it's something that we do look at rejecting and say, look, it's just not an option to go because it's limiting the governing body in their ability to actually function successfully and financially in a financially viable way. The restriction favoring non-payment of school fees at fee-paying schools. We're really concerned about the restrictions that are going through with regards to the exemption processes. The documentation there goes through it. Clause 22 looks at how we're going to handle those things in the future should this amendment go through. It restricts the rights of the governing body to decide on the exemption from payment of school fees. It restricts the information that may be obtained concerning the gross income of parents. it starts favoring that very dangerous thing called an affidavit. And for those of you that are further in the vicinity of where Rian is, I'll say it with a smile on my face, will probably know the point down below there that's just come up on the screen, the decree of divorce or divorce agreement, is irrelevant for the purpose of determining whether parents are entitled to exemption. That's going to be looked at quite heavily in the new potential or the proposed setup, which means you don't really have to still have a family unit, and the whole joint income of families with regards to applying for exemption falls away, which is going to create a huge financial burden on schools, because unfortunately we are in a society where, dare I say it, the husband, we don't know where the father of the child is, and then we're looking for exemptions, rightly or wrongly. It's something that's protected our schools a lot in the past, and we're quite concerned about that process. So the implications of these processes that are going to go through is that while schools are already struggling to make ends meet due to already a high percentage of parents who can't afford to pay school fees, those that are paying are going to be asked now to pay more, because those that aren't paying, that window is going to be open. I often consider this a sash window effect, and the more you push the window up at the top, the more comes in, the more air comes in at the bottom. And the concern is now we're making that window smaller, and that sash window that was covering the gap is now getting smaller, and you're going to get less air moving out the building, less money moving away from the school, if we put that analogy in place, and it's going to create a huge financial burden on schools. The proviso is still there are non-fee paying schools and there are fee paying schools, and parents who go to fee paying schools need to understand that they have got an obligation to pay fees. That's a statutory requirement. It's not a contractual obligation. It's a statutory requirement. If you enroll your child into a fee paying school and you can afford to pay full school fees, or part of the school fees, you need to pay them. And that's something that we need to consider and need to keep in place from there. I'll just go through the details there. The choice of attending a fee-paying or non-fee paying needs to be the responsibility of the parents. And the parents need to understand what that responsibility comes with, and they need to support the intent of it. So we're really concerned that the fee-paying or the non-fee-paying structure is going to be changed dramatically, and it's going to really impact on schools. Hence, that one also collects a rejection from us as well, and we're concerned about it. The Declaration of Spouse and Educator's Income, Clause 41, creates a provision, and we've already dealt with it with some of the principles. There have been circulars going around in KZN with regards to this declaration. Yeah, we're really concerned that the Education Department wants the financial interest of the spouse or cohabitating partner in the actual provision. Now, we need to have a look at this from the Public Fund Management Act, because that's a requirement that's come through there. And anybody from director level upwards needs to disclose their income and their spouse's income in the process. But the educators haven't up to now. One of the proposed amendments is that this is going to go through. More frighteningly, is failure to do so will constitute a misconduct process. So that is really a concern. For us, the main concern is that this starts impacting on the right to privacy, and it starts impacting on the protection of personal information. Where that information is going to sit is a great concern. If we put this together with the fact that the department can make appointments, and that they're going to be making appointments only on paper, this is one of the pieces of paper that they were looking at. And it won't look good. They may well make an appointment because they feel that this person needs the job and someone else has got a husband or a wife that isn't involved in education, that is running a very good business, and then they don't get involved, and then they don't make the appointment on that basis. That might seem a bit of a stretch, but my main concern is I don't know where this information is going to be safeguarded, and it's personal information. That information needs to be protected and managed. So that's something that needs to really be looked at so that we can actually understand where we're going to go with it from there. I really think it's directly a right to privacy, and this is going to be impacted on from that side. Okay, dispute resolution is another concern that we have with regards to the process, is that there's a clause that inserts a provision for dispute mechanism before litigation, okay? So if we put it in very simple terms, It guides both disputing parties to sit down and work out where they're going to go before they go to a judge or a court case and actually set it in place. Parties must now meaningfully engage with each other, and this will we hope that this, well, the idea of this amendment from the memo is that this will save cost, okay? Fortunately, you can't see me because I'm very dubious about the actual rationale behind this, considering Fedsas hasn't lost one court case in the last number of years with regards to this process, and we definitely haven't lost anything where we've had to pay the cost. So I think it's just a case of officials have actually overstepped the mark, they've been wrapped on the knuckles, and now we're trying to find another way of amending it. We're not so anti this, but it needs to be fleshed out a bit more, okay? Who appoints that independent arbitrator? That's really what our concern is. And how independent is that arbitrator going to be in the process? Clearly, if the arbitrator is appointed by the department, they're not going to be independent in the process. So we need to actually see how we can go about it. So we do support this. We support the principle in place, but we are looking for clarity on the mechanism of independence. And we do need to know that litigation is still in play. We do need to know that should we not be able to resolve things through a dispute resolution, that we have still got an option to go constitutionally if we need to all the way through to court procedures to get a court bearing on the process there. So it is very important that we have a look at it. So that we kind of will accept, but it's got a bit of a proviso that we have a look at it from that side. I'm going to ask Shane to step a bit closer because we are heading towards, there may be more questions to be answered, and I've purposely kept a lot of time available. I think if we can type up the questions, it'll probably be easier to handle that from that side. And if there are any questions, we'll then have a look at those questions. After the questions, I'm going to finish off with how we're looking at asking people to react and to put public comments in place. So if there are any questions, please fire away. It's fantastic to see the number of people that have logged in. Really great. Obviously, the recording is going to be going out there. If you found this useful, please let other people know. It's really just a snap overview. The 3 documents that are there with the information are vitally important. And so please have a look at them in detail. I've just really looked at the 5 or 6 concerns that are our major concerns. As I say, our first comment came out with 32 pages, and there's a lot of concerns in those that we need to look at. I urge you all to just have a look at your independent schools and see where you're sitting from that side. I'm going to hand over to Shane to see if there are any questions now, and then we can take those, and then we'll go through the last section about how to action. Yeah, Pamela, thanks very much for that. Yeah, definitely that is a problem, is the quality. It's the whole process, not just the price and not just the availability, but it's the whole process that goes with procuring the right goods for your school. And that's very important. It really reiterates the importance of individual schools looking at their situation and commenting directly on how this is going to affect their schools, because that's really what hasn't been taken into account. A whole blanket discussion has taken place to say this is a good way to run schools, but we haven't actually given schools the individual opportunity to actually comment, and that's what this public comment is about. So while, yes, Pamela, when you do respond, please say that the quality of the supply of procurement is important as well, and you may have had experiences when it hasn't, and use those experiences. There's also important that we remember to add our individual school setups on that from that side. Yeah, Rian, your question with regards to the department can now use the Mark Centrum in Nuxbetalni, heeltemal reg so, okay? Because that is a facility of the school, and if the HRD considers it reasonable to use it for an educational purpose, and I don't think any of us will deny the fact that marking matric results is for educational purposes, they could actually second you and force you to use those facilities. How are they going to fund and pay for the hostel accommodation? I don't really know, okay? But where they're going to find that money, they've got to come up with a plan. That's a very obvious reason why we're concerned about the facilities. And it's not something that we've always thought about when we sit down and try work out. And it's great that you've placed it in there that you can have a look. So that's something you've got to look at and say, what are we gaining? What are we going to lose in this process? And that's quite significant at the end of the year. I know a number of schools who run marking centers, and it's going to really affect it seriously on your financial side from that side. So that, for example, Rian, must go into your response and your public opinion that goes through, and obviously anybody else that puts it on there. The next question from Magda is, do you think that this law will affect the implementation of Bulletin 39 of 2017 regarding promotion posts in KZN? Magda, I'm a lot of things, but I'm not a gypsy with a ball that can tell you what the future is, unfortunately. Bulletin 39 is out in place, and I think while it's out in place, we must presume and we must work on it and get it done. So we mustn't hold back. I'm advising schools. I've got another online session in about 2 weeks' time with regards to just that process. So any of you that have got vacancies in that bulletin are welcome to join that as well. But in the meantime, we're advising schools to go along as per those timeframes, okay? And I know sometimes you say, well, is that not a bit bullish or stupid to go along with those timeframes? But if we don't stick to the departmental timeframes and we feel found short, then we're going to have a problem. Then they're going to take over the process from us, and legitimately so they can. So to answer your question, I can't say whether it will affect it or not, but I think because the Bulletin 39 is out and it's been released, we can actually go through the process. That does beg the question of the time frame with regards to this whole process. Should all the amendments be accepted and should public response be ignored, we have been told and we've estimated it'll be a year and a half before this might get through Parliament. But obviously in the meantime, there will be petitioning, there will be information flow. We'll be opposing or appealing the process as soon as we can, as soon as we're in the position to do that. We will then have a look at it as well. But I think we can safely say that Bulletin 39 is in play. Let's go ahead. Discussion with the Deputy Director of HR. They are looking to run either another bulletin or an addendum to pick up the bits and pieces that have been missed, okay? We have been telling them for years they cannot appoint 1,861 people in one setting successfully. There's always going to be problems. I didn't adhere to the advice of breaking it down into 4, but they are looking to run a second one, which we're confident as well of that from that side. Okay, Charmaine, must our SGB comment on every amendment or 46? If your SGB have got time, Charmaine, yes, I would say take out the ones that are of critical to your school. So go through the 46 and have a look at the ones that you can motivate as much legitimate argument or reason against or in support of as you go through them from that side. Some of them I say are technicalities. That's why I haven't gone item 1, item 2, item 3. I've just kind of thrown the ones that are of more concern. But the ones that are of concern to you, okay, that are going to affect your school directly. For example, if you are not a marking center, that aspect won't affect you, but you might have a swimming pool that is used and is hired out to the department for galas, or you might have a hall that's used for various functions. Those are the ones that you've got to have a look at from there. So I would say, yes, have a look at them all and see which ones are the most valid ones to comment. There's obviously going to be a repetition of the same ones coming through, and that will highlight the concerns of the more drastic ones, like I've tried to tackle it from here. Okay, Jose, I see you looking at clause 29. Let me just see. Can you explain this one to me as I read it? Maybe I'm reading too much into this one, but I see it in the minister making a new regulation that will bypass SASSA. Well, if we have a look at it, it does say the minister may make regulations. I've got it in front of me here, and the insertion on the management of learner pregnancy, admission of learners to public school, prohibition of unauthorized payments, minimum norms and standards. I would have a look at it and say, yes, there's a lot of regulations that the minister can just make without due course as to where we're going from that side. So that is a huge concern. Bear in mind, folks, that from the Fedsas side, we're also going to be sitting together and putting an extensive concern process in place with regards to them. And yeah, that one, for example, Jose, we will pull out and we'll flesh out. That's part of what this process is. I know we've only got a week left, but we've got enough time to actually put things in place. Our legal folks have been working day and night on this process to try and get as much comment that's sensible in place, that is going to be adhered, and then people are going to then stand up and have a look at. So yeah, Jose, that one I will then take through to you. As I said, I don't think you're reading too much into it. I'm trying not to be alarmist about this, folks, but unless we do something now and then the law does change, people are going to say, well, what did you do in 2017 when you had the opportunity to comment? And then we all say, no, well, we did nothing. And now we can't really complain. Also, if we're not successful, at least we'll have a trail of all this communication education, and we can say, hang on a sec, there was a lot of objection to it. So in the appeal process, when the law might change, we can then go back and say this wasn't in place, and we needed to have a look at it from there. Okay, the next question. Indien die skool toestemming op skrif ontvang het van die DWO dat hulle nie amptelike taal Duits as hooftaal mag aanwend, sal die nuwe wetgewing die brief onverklaar maak. Reg so, Ludwig. This is going to require, and this is where the really affect education in individual schools, and individual schools that have been running effectively well. Parents want their children in those schools. They sought after education facilities, and this is really what my main overall concern is that the constitutionality of democratic education is being taken out of the process here, and that's really what we're really concerned about. Gavin, you say, although the Department of Procurement buying power should benefit schools with being able to source goods at favorable prices, in reality, that we are able to source these goods from our own suppliers more cheaply. Precisely so. It's exactly what's happening. And Gavin, I will have a discussion off record with you, because at this stage I'm gathering information with regards to procurement that's happening in the Mgungunglovo district, precisely because of that. And people are getting told, although they've placed orders, principals are being told, don't unpack those orders because they've got to go back to the suppliers. So yeah, there is a serious concern about it from there. Rian says, ek het Fedsas opsomming op PNS se DSS geplaas vir ouers om na te kyk, enige ouers kommentaar lewer te hou, en hoe excellent. 240 kinders se ouers is nie in vryheid nie. Ouers is nie in vryheid nie. Okay, that's great. It's great that that information is going out. Most of you know that I've got a bit of a bias towards D6 because I'm involved there as well. But at this stage, please use every media that you can to try and get information out. Just now, I will get through to showing you where we look people, asking people to comment, and the D6 has come on board nicely with a national campaign of actually promoting an avenue where comment can be made, where parents can actually make comments, and I'll mention that just now from that side. Deval Delports, clause 8, what if a non-viable school in our area, what if a non-viable school in the area joins our school? Does this improve? Then apply. Does this rule then apply? Mark from Underbeck. Okay. Yeah, Mark, you did send me a message earlier, and that's, yeah, clause 8. I'll skip clause 7. Clause 8 was really a concern. And I think, yeah, it suddenly straight away takes away the whole idea of wanting to support schools in the area and now being forced to support schools in the area. And it sort of forces twinning onto schools. Governing bodies that have tried it before in the past, governing bodies have been asked to twin with schools, but there hasn't been a cooperative two-way process in that setup. And so schools have been hesitant to twin. And I think that is a concern. It now starts saying viable schools. I don't want people to panic, but I heard a figure of 135. I was trying to find the details on it, but I did hear a figure of 135 or less being a non-viable school. Exactly what happened with the hostel scenario. Some hostels at 90 are still viable. Some schools at 120 are still viable. So we need to be very careful on that process, and we need to object it from there. Susan Marais of Susan Marais, in the area where e.g. Afrikaans is a minority, will the HRD be able to change the policy and force learners to go to schools out of the area? The proposed changes allow an assessment on language policy at least every 3 years, and forces an assessment every 3 years. And if they feel that Afrikaans, and I'll use it because that's there, is Afrikaans is not a viable language to teach in the area because there are less and less people teaching Afrikaans, HRD can actually say you need to change your language policy. And until you change your language policy, he won't sign the approval on the language policy, and you aren't going forward. So yeah, that's a huge red flag. It's something we really got to consider. Doesn't only apply to Afrikaans, but it could apply to other languages down the road, where they say, well, suddenly now maybe we've got to teach in an indigenous language, and we've got to reduce English as an example from that side. So that is a concern. Des Millen obviously got back on board. Well done, Des. Obviously got some connection with NASHA and got sorted out. What is the change? What is the change that the change in BELA be installed as? What will the purpose of an SGB? Placing an SMT appointment with the person not even having experience at school. Yeah, I really can't say what the process is. It does depend on the public opinion that comes through and on how the powers to be actually consider that public opinion. Whether they blanketly just ignore it or whether they take consideration into it. At this point, our drive is to get as much public opinion in place. So as soon as we get public opinion in place, then we can start saying, well, okay, these are the steps that they're going. And hence why we've had this drive, that we get as much information through as possible. It is late in the day. We've got a week left, but folks, I'm going to go on to the next one. I think that's all the questions there. I'm going to go on to the last slide just to show you how we asking schools to comment and how we're going to handle the process from there. So yeah, thanks very much for those questions. Hopefully it gave you a bit of an idea of where we're going. I'm going to move over onto my screen now, and then we can just have a look and see where we're going in that process from there. Okay, we've gone through questions. Just so that you know, that's my email address as well, okay? Those of you that are fancy can take a screenshot now. The rest of you that aren't fancy, better start writing down that number. If you want to send me an email with regards to further questions, it is going to be a busy week, and we are going to be getting back and answering the questions because we have to answer them before Friday. So please, if there are questions about how you want to go about it, if you've got concerns, what we need to look at, please ask the questions. That's really what this whole session has been about, to provide that channel for you to ask those questions. Okay, so to give you an idea of where the comments need to be sent and how we're going to handle this process, or how we're looking to handle the process, in the documentation that's come out from the Department of Education, the General Director, that's the PO Box number, that's his fax number, and Advocate Rodman is the person who's collecting the emails and running through the details. So that's where the comments need to go through. What we're doing, we're asking schools, okay, governing bodies, with parents' petitions if possible. And I know it is limited and everybody rolls their eyes at the stage and say, how can we do that at short notice? But some schools have already started doing that. If not, at least on a school's letterhead signed by the governing body in support of the parents at the school, your comments and objections need to be placed on record to Advocate Rodman at that email address, okay? We are asking you also to please send a copy to that email address, okay? rpo@fedsas.org.za. That will also allow us to gather the comments. We're not going to push them forward all through. We're asking you, and the requirement is that you comment directly to the various channels there, but give us a copy as well so that we can compile records. Should we need something for appeal down the road, we don't have to ask you for all the information again. We've done it in one go. So we're asking you, once you've put your documentation together and you're sending it through to Advocate Rodman, please also send us a copy as well, okay? Just please put your school's name on it because they're going to get lots of BELA comments, okay? So please put your school's name and BELA comments so that our legal officers can all file it and can store it correctly from that side, okay? If you can't send it through to RPO, send it through to Fed. I will pick it up, and we're already gathering some information that's going through. I have had a school that sent me information, so they weren't sure where to send it. I obviously will send it on their behalf, okay? But please, the more you can communicate directly from there. You will notice, and I said it in the very beginning, we can't just send a templated response out and get everybody to sign it. That's not going to look like people have actually applied their mind to the individual impact at their schools. So we've given guidelines as to where we're concerned. But the examples that have come up already, you can see there's plentiful within your school that you can look at. Doesn't have to be in fancy legal term. So it's got to say, these are the impacts that you see. What is the response to them? We need to have a look at it and see where the concern is from there. So that's really what we've got to look at. Okay, and as far as parents go, okay, we're also asking people to comment on parent side. D6 have been fantastic in that they've run a poll or run a Google form, for those of you that know how that is, an electronic collection point on the D6, okay? So where it says proposed basic education law amendment, on the D6 that goes out to all the parents, there is a click through there, okay? Submit your comments by clicking. You can click on there and you will go through to a very short form that you can actually fill in and actually submit, okay? When I say you, the parents, please encourage the parents. Put a note on your D6, or if you've got other communication tools, let's find that information and get it through to you, okay? So make sure that the parents also comment, that we fill those comments that go through. Those are going to be gathered and then submitted through to Advocate Rudman as well. And we're really grateful that D6 have done that. It's very short notice. They've put that banner on there in the advertising free of charge for us to get these comments through, because this is going to affect public education. The face of public education is going to change unless we have a look at this very carefully and unless we object at this moment. Okay, the other petition that I've picked up, and there might be a few others running, okay, so I'm not saying this is the only one, but please encourage your parents as well to look at the petitions and place the petitions in place. This petition this morning was sitting at 6,000 signatures, and the latest one that's come through is now sitting with 10,499. That's been in the space of a day, okay. So it's important that if you see petitions that are going out, I know Solidarity, we're running a petition as well. I know some of the unions are running petitions. So please comment on those petitions and get your parents to comment. It doesn't help to sit there and say, what did we do in November 2017? No, we did nothing. So now what are we going to do? We're going to complain. We'd rather put something out there now while there is space for public opinion. Not promising you that we're going to change things, but if we don't put anything, we're definitely not going to change things. So we need to put communication out there. We need to put that information out there. I will have everybody's email addresses. So what I'll do is I will send you the email link to the petition so that you've got the details. I'll also send you the link to the D6 form as well. So if you haven't got the D6, you can still send that link on and people can submit information through there. These two channels are really for the parent side to submit. It's really important that governing bodies submit directly through to Advocate Rudman on details about this. Otherwise, once again, what did you do in November? No, we did nothing in November. Now we sit with the problem from there. Okay, and I think that is about where I am. I've just put that up there just to remind you and just to give anybody opportunity if there are any more questions. If there are not any questions, please feel free to send emails. I'm expecting lots of emails this week, so please make sure the emails come through that we can actually respond and get back to everybody and give them as much guidance as possible. Once again, the documents that you will find there will give you a guideline of what our overall concerns are. They might not be your individual concerns, but they'll give you an idea of what our concerns are. And then we can start having a look at them and we can start handling them from that side there.
And yeah, I just want to commend everyone on joining in. If I calculate the percentages correctly, we're close on 70 people. I think maybe just two things as a governor on my own school, my kids' school's governing body. What we've done is to rally a lot of what Paul has said. So the SGB is putting together a strong letter, and we've asked parents to sign in support of that, and also asked them to write their own submissions if need be. And it coincides very well this week with a lot of our award ceremonies taking place. So we don't even need to get the parents to come to the school specifically to sign. So rally the opportunities that's already there. If you have an award ceremony at the school, have a table there with the letter and sign-up sheets so that people can sign up and join the process and just support the letter from the SGB. And I think a lot of schools are missing the opportunity for the teachers to do submissions as well. You know, it's all around them, but I think teachers can sit during one break and just write one-liner and rally that support as well. And then I think just to add to what Paul said, I think there's a lot of social media activity around this, and join the hashtag, share on your school's Facebook page, Twitter feed, whatever it is, share the D6 link that goes to the online poll or the Solidarity one or whatever online activity there is. That's just, you know, posting an already existing post on Facebook, and suddenly you're sharing it with all your parents and followers on social media. And then lastly, maybe, you know, not to take all the negative from it, is to also remember to support the one or two issues that we are in support of. I think it's always good to be fair in your comments, and let's nail the difficult issues which Paul highlighted very well. Let's nail those hard, but there's one or two that you can frame in the frame of better governance, better management, and better school performance. So let's support those. I think it's probably two issues only that I've noticed in the clauses, but let's make sure that we you know, at least give ourselves some credibility in saying there's one or two big good things coming out of this as well. And yeah, further than that, I can't add more rather than to say, Paul, well done. Shane, thanks so much. And yeah, it was great joining you guys. If any of you have contacts with any schools in Gauteng that might want to join this in future, let us know. We will advertise this as well, because I think it's a great platform to get to schools without traveling far. So that's a few comments from my side. Thanks a lot, Shane.